How can you avoid getting trapped by the 3 most common Social Security disability myths? I'm Jonathan Ginsberg, and I'm a Social Security disability attorney. And over the years, I've spoken to many people, and there are, unfortunately, a lot of misconceptions about the Social Security disability process. And I wanted to take a few minutes today to talk to you about 3 of the most common myths that I hear and to tell you the truth about what really goes on behind the scenes. The first myth is kind of a general one, but I'll call it the truth will win out. People say to me, I'm disabled. I know I'm disabled. My whole family knows I'm disabled. My doctor tells me I'm disabled. What's the big deal? Why won't Social Security find that, in fact, I'm disabled? Well, unfortunately, Social Security disability is not about right or wrong or truth or falsehood. It's really about evidence. So whether or not you're disabled and you know it in your heart or your friends know it, that's really not relevant. What we're facing is, let's talk about going to a hearing, that a year and a half, 2 years from now, we're going to have 45 minutes in front of a judge to prove that, in fact, you are disabled. The judge may have looked at your file for 30 minutes or an hour the weekend before, along with 15 or 20 other cases. So the judge doesn't know you. The judge hasn't lived in your shoes, hasn't observed you. All the judge is going to be going on is what is the evidence in your file. And without compelling evidence, judge is just going to say no. And again, a lot of these files, when I'm looking at them, there may be 14 or 15 exhibits, there may be 1,000 pages of records, and a judge is going to kind of peruse those, but realize that unless something important is highlighted, and that's again what an attorney like me will do, that on exhibit 7F, page 43, there's an MRI report that shows you have a significant disc herniation with radiation into your lower extremity. If that's not pointed out to the judge in my opening or pre-hearing brief or as part of my direct examination, the judge may miss it. And so we have to build a case. We've got to come up with a theory of disability to explain why you meet Social Security's definition of disability, and that would be that you do not have the capacity to work. If we don't have specific evidence talking about work capacity problems, the judge is going to say, there's just not enough here, deny, and move on to the next case. So it's my job, and it's your job to some degree, to point out specific bits of evidence that will support your claim for disability. This typically is in the form of medical records, but it could be a statement from a former coworker or supervisor. It could be observations from your parents or a sibling about how you've changed over time. All these things are a part of a big picture, but the big issue is whether there's any kind of work you can do, and you should not and cannot assume that Social Security will, or a judge or an adjudicator will go through all these pages of records and figure all that stuff out. Realize your doctors are focused on treating you. They're not focused on a disability case. So whether or not you're disabled or not is something we've got to pull from the record. It has to be identified specifically, but don't assume that Social Security decision makers like judges or adjudicators are going to find it unless we say, here is a red marker, here's a yellow highlighter, this is where it is, this is the specific page of evidence, and I have you talk about it in direct testimony. All right, second myth, Social Security is going to get all of my records. They're going to develop the file. And so when I go to a hearing, my file is going to be complete. Unfortunately, this is wrong as well. Social Security has a system, and they have an obligation to develop your medical record. Well, what form does that take? Basically, what they will do is when you file your claim, the adjudicator will send out requests. The adjudicator is kind of like a claims adjuster. They'll send out requests for medical records to the doctors that you have identified in your application form. And the records that come back they'll use to make a decision. Well, a lot of times doctors don't reply to these requests. Doctors get requests all the time. It's expensive and time consuming. Also, a lot of doctors use outside copy services that are at a different place. So if you send a request to Dr. Smith on Peachtree Street, for example, Dr. Smith's office may not be responsible for gathering those records. They may use a copy service. So that request has to be sent to the copy service. They will then have to process it along with thousands of other requests from other lawyers and other types of cases. And it may take 6 weeks. It may take 2 months to come back. In the middle of a pandemic, it could take 3 months. I'll tell you, when I request VA records now, it can take 3 or 4 months to get those records back because some offices are not fully staffed. So it's really important, and what I do, and believe it or not, I spend a lot of time, my paralegal spends a lot of time with this, is we will get on the phone, we'll call the doctor's offices and say, what is the address that we should use to request medical records? And then we send the request to those particular places, or for filling out forms for Social Security, we use the address for medical record requests. Really important to do that, and you can really help yourself by finding out early on what the address for medical records is. Give that to Social Security, give that to your lawyer, so that we're not wasting time trying to track down records from a place that they don't, is not being actually processed. And I've had many cases, several recently, where we requested medical records 3 or 4 times, and it turned out that the request was sent to the wrong place. And one time in particular, we called the doctor and said, where do we send the request? Here's the address. They gave us the wrong address. So these sort of things happen. It causes delay, and when there's delay, records don't get submitted, missing records, a judge or adjudicator says gap in treatment, no, it's not serious, the person's not going to the doctor, we're going to go ahead and deny. Third myth, I hear this all the time. I worked, I paid my taxes into the system, I want to get my money back out, why are they holding on to my money? Well, newsflash, Social Security does not see this as your money. Social Security sees this as a trust fund where money from taxes from millions of people is being deposited. And generally speaking, Congress has already spent that money. It's an IOU. So this is not your money you're getting back out. They're seeing it as their money, and it's their job to prevent you from getting your money, because they want people who are filing for disability. They only want to approve the most deserving people, and there's a narrative, a non-factual narrative, in my opinion, that most people who apply for benefits are not truly disabled. So they're going to fight you every step of the way, is what it boils down to. So what that means is that when you apply for disability benefits, you're in for a fight. They're going to try to not pay you. That's why, if you think about it, why do they have the reconsideration appeal stage? Less than 10% of claims are approved at reconsideration. It simply wastes 5 or 6 months, and all that it does is it discourages some people. They drop out and go back to work, again, to fulfill that narrative that people are really not disabled, or they simply give up and they live in their parents' basement. It causes a lot of hardship, but it's basically a 6-month delaying tactic to keep money in their account, not into yours, because when it's in their account, it's not, they either can earn interest or it can be used for other purposes. So Social Security has no interest in you as personally, that they don't necessarily have a bias against you, but they don't necessarily want you to get their money, and they see it as their money, whereas you see it as your money. So if you believe that you're simply getting your money out when you apply for disability benefits, understand that Social Security does not see it that way at all. They see it as their money, and you've got to prove to them that you're deserving of it. And then once you get benefits, you've got to continue to prove to them through the continuing disability review process that you continue to be entitled to disability benefits. So it can really be a challenge. So anyway, those are the 3 myths that I hear a lot of. I hope I have clarified a little bit of how Social Security looks at it and why you should not fall victim to those myths. If you have any questions, please visit my website, ssdanswers.com. You can download my Secrets to Winning Disability Survival Kit. You can ask for a case evaluation. And if you do find this video helpful, please give it a thumbs up on YouTube, like it on Facebook, and leave me a comment. I'd love to read the comments, looking for ideas for different videos, and love to hear from you. Jonathan Ginsberg here, wishing you the best. Thanks a lot.